up, we have another professor, Amy Hardberger, the director of the Texas Tech University Center for Water Law and Policy, who I think you've been there a year now, right before the summit last year when we were virtual. She's going to be speaking about ownership in place, another hot topic when it comes to Texas groundwater law, what it means and what it means for the future of groundwater litigation in Texas. Welcome, Amy.
So I think what this presentation and the one before shows you is that this is what happens during a pandemic for academia. We just sit there and come up with all kinds of exciting notions that then we turn over to you and you get to decide how lunatic they are. So I definitely fall in that category. I'm certainly not going to say that the other speakers in that category, but I'm in full sit quietly and think mode. So really the preface of this conversation is that, like you guys, I've been sitting in these rooms ever since the Day decision wondering what the legal future of groundwater is and watching how it's progressing and trying to maybe change the conversation a little bit as we go forward and think about all the property interests and not just a specific quantity of the property interests that have been we've been focusing on a lot in litigation. So the Day legacy is really about property rights. I think everybody here is well comfortable with that. I'm going to question the notion of whose property rights and what does it really mean for the folks that want to exercise the property right to mine groundwater or get these particularly larger permits, but not specifically. And you guys are all on the front line of trying to figure out how to do that in the ways that would meet your own needs or DFCs. So it's always nice to start with the law and what Day says. I think we all know the first part of what Day says, but something that we're going to focus on in this talk is the second part of that, or maybe the third bullet, which is it is very clear when you read the opinion that GCDs still have a right to regulate, right? And all of the case law that's come after that has recognized that. And what is important about that is that it can be easily paralleled to other areas of property rights regulations that I think have not been capitalized on yet in our litigation system. So that's why it matters. I'm not going to go through, this is not a case law update, but I do think it's important for us to see where litigation has been going more recently. In the two big buckets that I've seen litigation, this is by far the biggest, the takings bucket, and equal protection is one of the other ones. This is not an exhaustive list. This is just to give you an idea of when I see these, I start to see a bit of a drumbeat of property owners asking for permits and either being denied the permit in full or being denied a portion of the permit and then suing for a takings. That is a gross oversimplification of some of these cases. They are extremely complex, but when you take it down to why it is the complaint was brought, there is a takings focused on these, right? All citing back to Day. And of course, everybody knows that we have one big takings case that has already gone through, and that's Bragg. I like to caveat Bragg and remind us that it had a very specific and I would say extreme fact pattern. And so I think a lot of folks look at the bottom line of what the Braggs were paid and they see an opportunity there. And the litigators that I know who get these phone calls on a regular basis like to remind these people, these potential clients, what the chances are that they're going to see anything like what the Bragg saw. And even if they do, it's always a nice reminder to the person how long the Braggs had to litigate in order to get that verdict, right? So that's kind of the other side of the ledger. So I think everybody's pretty familiar with what the takings argument is. The other one that we're seeing more and more is equal protection. And equal protection, for those of you who are unfamiliar, is a constitutional obligation to not treat similarly situated people differently. And so most people are familiar with equal protection in the race and gender areas, but there are different tests even for anything really. It's just a much easier test to defend. And so what we're seeing in equal protection is this move of saying, you're treating that water owner or that property owner differently than you're treating me. And so the place that we're most commonly seeing this in litigation is historic users versus existing users, or any two types of permits. There have been a couple of different litigation pieces where people have said, I'm a brand new user, I have this set of rules that applies to me in the district. That historic user has a whole different set of rules and obligations applied to them. That's unfair. Generally, the courts have not found that to be true. The devil's in the details and how you define what the class is. Just yesterday, I received the opinion from the Fazzino? I don't know how you say it, Fazzino? I'm looking at the lawyer. Case, and the court granted summary judgment for the Groundwater District, saying that that there was no equal protection claim and that it was okay that the class was existing. These different types of permit users were allowed to be treated differently. What's important is everybody within that type of permit is treated the same. So these are sort of the background on which we look forward and think, okay, well, how are courts and litigation going to be part of this conversation? And while I would love it if this stuff was not handled in the court, the reality is that a property interest was given to surface estate owners in day, and they are really the only ones that can fix it without a major takings problem, right? So if the legislature wants to come in and now change the thing that they refused to change since East, and they want to do reasonable rights or something different, that is going to be a major problem in the takings front, I think. The court has the opportunity to overrule themselves on day, but I think if we took a hand vote in this room of how likely that would be to happen in the near future, I would not see a lot of hands. So thinking about the courts are going to be involved in whatever the next step is, and that means that groundwater districts are going to get a front row seat to whatever this is. And the problem that I have with the way that this has progressed is I think that day has created a bit of a distraction. And the people it's a bit of a squeaky wheel problem, and the folks that are talking loudly about my property rights, I want to be able to access that water, is often being heard a bit louder than the other equally important property rights that don't want the water to be drained. So the interesting thing about when the Day case came out was it was hailed as a huge victory for property rights. But what I always say back is, well, whose property rights? It's not unusual for me to get phone calls and say my neighbor is stealing all of my water. This is a 5th generation piece of property. What makes it beautiful is the spring, and they're taking it, and I'm having to explain to them what the Day case said. But all of that got me thinking, well, hang on. Why are we, if we're really thinking about property rights, and more importantly, if groundwater districts are on the firing line to figure out what these property rights are, it's important for us to think about all the property rights holders when we're having those conversations. And we need to shift away from the distraction and into the outcomes. What is it that we want to happen? And I think that the initial panel today kind of set me up, for a lot of these issues, and that is, is it the DFCs? I think that, again, if I were to do a hand raising, which I kind of want to do just because I haven't been in front of actual humans talking in a year and a half, which is super weird. So I kind of want to call on somebody, but I won't do that. What is it that we want to do? Instead of being reactionary to this litigation, maybe we should be thinking about the bigger picture and what we're trying to achieve. And I don't think anybody really wants us to run out of water, right? So the presentation just before me sort of, there are real potentials for that happening. By the way, in my water law class, every time I teach it, on the first day of class, I ask everybody in the class, who thinks that we can run out of water? And it's amazing how few hands go up. And then I ask the question at the end of class, and a lot more hands go up because they understand that the law is not always there to protect the resource. In fact, it's not really ever there primarily to protect the resource. But groundwater districts are obligated to think about the resource. So there's a bit of a paradox there. So I don't know why this isn't, there we go. So in thinking about the outcomes that I wanted to focus on, that I was sort of picking up out in the ether, one was thinking about how other property rights holders could have more power, more legal power behind them, and that if they have more power behind them, that means groundwater districts have some downside protection to be denying these permits. That there might be other reasons that could be put forth for why these permits shouldn't be issued if there's going to be a negative impact either to other people or to the aquifer, DFCs, you name it. And then I think the other outcome that I was thinking about was the broader outcome, which is I would like to continue living here. Many of you would like to continue living here, and water is obviously maybe the most crucial element for that happening. So I sort of divided my thoughts into these different sort of categories. One is, let's take another look at the Conservation Amendment and public trust. And I know everybody kind of rolls their eyes at public trust, like, oh, but we actually have public trust all over Texas law. And so there's quite a bit of, when you start looking at the words of what are in these big, boring books, there's some interesting things in there. The second is something that you guys are well familiar with, and that is the statutory obligations of GCDs to do things like management plans, DFCs. I am fascinated by the waste issue. We're going to go into these. Looking at takings again, and then I think at some point we are going to have to really start talking about surface water rights again from a legal standpoint. I think everybody's familiar with the Conservation Amendment. It's why groundwater districts exist, right? Like it was the authority for which they could be created. I like to reread it from time to time because there really is some beautiful language in there about the value of natural resources and water in particular and our obligation to protect them for the public. And this is 100% public trust language, right? That it's owned by all of us and held in trust by whatever regulatory authority is there. And we're seeing the public trust doctrine being expanded to other things. Public trust doctrine was initially about access to surface water, that you can't prohibit access to some surface waters, like navigable surface waters. But groundwater is becoming an interesting conversation piece for public trust. Hawaii extended the, oh, I have another little thing there. Hawaii extended the public trust to include groundwater using very similar Hawaiian law that sounds extremely similar to Texas law, interestingly. And so here the principle is to guide management of common resources. It's not a law, it's a principle, it's a way we approach things instead of the biggest pump wins. And the focus is really on the resources that are shared by all of us and with the goal of protecting it for future generations. And then if we are dewatering aquifers and without sort of, thinking about those principles, we are working against at cross purposes for what the public trust is. And as I mentioned, in 2000, Hawaii extended it to all waters of the state, and the language of what they based, a court did that based on language that they found in state law that sounded almost exactly like our Conservation Amendment. So it sounds esoteric, but it's not that big of a stretch. I'm not going to spend a lot of time on this because I think you guys are the experts on this, but let's remember that groundwater districts' statutory obligations, their stated purpose includes the word conservation, the name includes conservation. So clearly when we think about what the legislative intent was when Chapter 36 was being created and then later bolstered in different laws, the intent was to maintain the water into the future. Groundwater districts, as you know, have to do management plans. They then have to promulgate rules that are consistent with the management plans. When you go down into the rules to see, well, what needs to be in a management plan, The word conservation is all over the place, not to mention words of groundwater protection or source protection like recharging. So very clearly in that is this obligation to protect. And then, of course, desired future conditions are, a translation of how we are going to meet those initial goals, and a groundwater district needs to work with the DFC as they promulgate their rules and make sure that they're trying to meet that goal. So plenty of that was discussed in detail from the district standpoint earlier today. Where I see one of the biggest opportunities, for lack of a better word, in groundwater litigation is this idea of waste. We know that groundwater has to be used beneficially. We don't have many rules for groundwater, particularly if you're in a white area, but we know that you have to use it beneficially. Waste is not beneficial, period. But we don't really know that much more about waste. We do have, this is the definition of waste, and I'm just sort of I just sort of bolded a few things because I know that's a lot of words on a slide. Not for beneficial use, the idea of escape, willful, negligent, these are the types of words that we're looking for. What's interesting to me is how little we've discussed waste in the law. The big waste case that we talk about all the time is Corpus versus Pleasanton. It's from, I think, the 50s, I'm forgetting. And it's not about, it's a bed and banks permit. It has to do with how much water is being lost through carriage losses as it goes from one place to the other. We've never really dug in and talked about waste as it pertains to a particular user, or denying a use because of waste, or somebody suing someone due to this violation, or potentially, I guess, suing a groundwater district for allowing a waste to occur. There is an interesting conversation on the LCRA Lost Pines issue that was in front of the State Office of Administrative Hearings. One of the reasons that the initial LCRA permits were denied was that there was a worry of carriage losses and that they felt like that would be a waste. And so we're starting to see, I think, this idea of, well, wait a minute, how are you using that water? And I think that's a natural progression of how we're going to talk about water. When there's plenty of something, nobody really cares how they use it, right? But when things start to run out, the example I always give my students is, if you have a friend that you know is terrible with money, like wastes money all the time, and they ask you, hey, can I borrow $20? You're gonna be a lot less likely to lend that person $20 than a friend that you know does everything they can and really just needs your $20 to get by. And so I think we're seeing that same type of accountability increase when there is this shortage and we're starting to take water from one place to the other. We definitely see this with these long-haul groundwater transfers. I'm on the SAWS Board of Trustees, and I can tell you that there are a lot of people that are very upset. I was not there when Vista Ridge was voted on, but who feel like, well, how are you using the water that you need to take our water? And I think waste is really embedded in that particular conversation. This is the thing I love to talk about the most, and I'm sure I'll run out of time on it, so we'll just throw it out there. But takings actually can cut both ways. And so when you, not to give a whole takings lecture, but I love teaching land use because there are 3 prongs to the Penn Central analysis, which is what most takings cases in Texas, it's partial economic deprivation. There are 3 prongs, right? The economic impact, which everybody likes to talk about on the property owner, the interference with investment-backed expectations, which everybody likes to talk about, and the one that we don't like to talk about as much, or at least was definitely not that big of a conversation in the Bragg decision, is nature of the government action. And when you look at where we might be going and where this idea of the regulation that the groundwater districts are trying to move forward, I would say it's a perfect parallel. I mean, all of the inverse condemnation takings, which is what this is based in land use. It is, this is my private property, and there is an entity, in this case the city, that regulates me heavily for the benefit of the good in using the police powers. And so we really don't, people love to talk about this is my property, I can do whatever I want. There are very few places, certainly if you're within any kind of an incorporated area, that you're actually going to be able to do that. And so when we think about groundwater litigation evolving, takings groundwater litigation evolving, I think there's a very different, courts can decide it a very different way based on the character of the government action. It's hard to imagine something more important than preserving groundwater for the greater audience. And that can, a whole takings claim can turn right on that. And then the other thing is whose property rights, right? Like, are we forgetting about the property rights owner who does not want the water to be withdrawn? Does that person have, what power does that person have in the courts? And so I think there's some interesting places that this can evolve. And the last thing is, let's revisit surface water. Again, when we talk about other property interests, there are people that have surface water permits that are vested rights that they have held for a very, very long time. And the one case that we really have that says there's no liability between surface water and groundwater is the Comanche Springs case, which is quite old and in a very different world than what we live in now. So I can see in the future some, whether it be Dow Chemical or, a power plant. Imagine a power plant that has a surface right permit that can't run a power plant because the surface water has been drained from somebody pumping groundwater. It is hard for me to believe that that's not going to result in some litigation and perhaps a different answer than what we saw many decades ago. So these are my crazy COVID ideas, and I am happy to answer any questions if anybody has them. I'm not saying, by the way, I'm not a litigator, I'm academic, so I get to say all this stuff, and I don't know if it's going to work in court. That's your lawyer's problems. That's not my problem. So that's what I'm here to do.
So I did have a question, actually two come in.
Okay.
And this goes to the ownership in place topic you mentioned before.
Yeah.
How can someone who owns water protect it in place, and what can a GCD do to protect groundwater in place?
Yeah, I mean, it's hard under our current system. There's no two ways about it. And by the way, oh, and I should mention this came from, I wrote an article. This is a portion of that article. It's out, it'll be in publication in the fall. It's going through the editing process, but if anybody wants a copy of it, you have massive insomnia, let me know. It's stupidly long. But yeah, just email me and I'll throw that your way. So, but the article and this conversation is really focused on areas that have GCDs. So I just want to put a little asterisk and say white areas are a much bigger challenge. You're really left with some common law claims. And so, I mean, the only way to protect it, I think, is if a GCD builds that into their rules and as part of their DFC. I mean, I think that it would have to be done through the permitting process. Almost, I mean, we see that on the surface water side, where you have freshwater flows or environmental flows. We recognize that a certain amount of the water should just be there. Now, somebody may still have to lower their pump. That's kind of a different issue, but I'm talking about a more permanent dewatering. But under our current system, it's a huge challenge.
So I combine those two questions. Are there any in the audience? All right, wonderful. Thank you so much.
Thank you.